He thought he was smarter than the justice system. A 17-year-old honors student with a genius-level IQ, no criminal record, and a smirk that never left his face. He didn't just break the law, he mocked it. Mocked the prosecutors, mocked the court, mocked the entire idea of consequences. Because in his mind, he was smarter than everyone in the room. They follow rules. I write them. But what he didn't know was that the judge wasn't here to play games. She was here to make an example out of him. Before we show you how his arrogance came crashing down, make sure you're subscribed with that notification bell turned on, and drop a comment telling us where you're watching from. Because today, you're about to see what happens when the justice system decides to make an example. The Travis County Justice Center sat hunched under the heavy Austin heat, its walls stained with decades of disappointment. Inside, Courtroom 4D buzzed with tension that made even the bailiffs speak softer. 17-year-old Nolan Voss had arrived early, walking through the doors like he owned the place. He didn't need directions, didn't look nervous, just claimed his spot at the defense table and opened a worn leather notebook, scribbling diagrams with a silver pen. When someone in the gallery whispered his name, Nolan looked up and offered a small wave, followed by a wink. His public defender, Scott Klein, looked like a man trapped in a chess game where his queen had turned on him. Middle-aged and clearly exhausted, Klein flipped through his legal pad without making eye contact with the boy beside him. Across the aisle, Assistant District Attorney Maria Benton clicked a pen in rhythm with her breathing. Known for her composure and for never losing tech crime cases, she didn't glance at Nolan even once. At exactly 9 o'clock, the bailiff called everyone to rise. The courtroom obeyed, everyone except Nolan. He remained seated until Klein yanked him upright, rising with theatrical slowness like a bored prince summoned to court. Judge Melinda Rowan entered with the measured stride of someone who'd spent decades watching human nature at its worst. When her gaze landed on the defendant, something flickered across her expression, recognition of the type, the smart kid who'd never been told no. Calling case number 24-178, she announced. State of Texas versus Nolan Samuel Voss. The charges made jurors sit straighter. Count 1, wire fraud. Count 2, identity theft. Count 3, obstruction of justice. Count 4, witness tampering. Nolan's only reaction was to mouth the word "for" and offer a small shrug. Judge Rowan's eyes narrowed. Mr. Voss, you'll maintain appropriate courtroom decorum. This is not a performance. Do you understand me? Crystal clear, Your Honor. But he said it with that smile, the kind someone gives when they're already 10 moves ahead. The clerk stood with practiced formality, her voice crisp as she read each charge in full legal detail. Wire fraud, the use of electronic communications to defraud victims across state lines. Identity theft, the unlawful use of another person's identifying information. Obstruction of justice, interfering with law enforcement investigations. Witness tampering, attempting to influence testimony through threats or coercion. Maria Benton rose with deliberate calm, walking to center court with a manila folder. Ladies and gentlemen of the jury, this case is not about a misunderstanding or youthful curiosity. This is about a 17-year-old who believed he was smarter than everyone in this room. His name is Nolan Voss, and for the past year, he has operated a systematic digital predation scheme. From the defense table came a suppressed chuckle. He hacked into Hartley College's protected systems, accessed personal records, social security numbers, bank information, medical files. Then he used that information as weapons, blackmailing students for money, manipulating records to frame innocent people, forcing one victim to lie during a campus investigation. She turned to face the jury directly. You'll hear from the university's IT director about security breaches that shouldn't have been possible, from students whose lives were turned upside down, from the detective who found organized files on Nolan's computer, spreadsheets categorizing classmates by vulnerabilities, blackmail strategies, even video recordings of himself bragging about his leverage empire. Her voice dropped slightly. He believed this courtroom would be another stage for his performance. But this courtroom runs on facts, on evidence, on truth. And today, we're going to show you exactly who Nolan Voss really is when the masks come off. Scott Klein rose like a man walking to his execution. My client is 17 years old, a student with no prior record, gifted for it, but he made serious mistakes. He got caught up in the intellectual challenge, the puzzle solving, the adrenaline rush of proving he could do something others couldn't. While Klein spoke, Nolan sat with arms crossed, staring at the ceiling like he was counting tiles. He didn't set out to hurt anyone. He got in over his head. All we ask is that you remember his age, his potential, his need for guidance rather than destruction. From the defense table came a stage whisper. My opening would have been way better. Judge Rowan's gavel cracked once. Mr. Voss, that's your first warning. Benton wasted no time. The state calls Richard Kwan, Director of Information Technology at Hartley College. A thin man with rectangular glasses walked nervously to the witness stand. After being sworn in, he glanced briefly at Nolan, who offered a friendly wave, and quickly looked away. Mr. Kwan, what first alerted you to security breaches? Students complained about password resets they hadn't requested. When I checked the server logs, I found someone systematically accessing our student information system using legitimate credentials, but the patterns were wrong. Multiple logins from the same IP address in alphabetical order. And you traced this IP address? Yes, to a dormitory connection registered to Nolan Voss. Several jurors turned to look at the defendant, who was taking notes like he was documenting his own prosecution. What did the intruder access? Everything. Student records, financial aid, disciplinary files, medical exemptions, even sealed conduct review files restricted to senior administrators. Benton held up a highlighted document. Can you read the entry from January 13th? User NVOS17 accessed disciplinary archives at 11:03 p.m., spending 47 minutes in files marked misconduct restricted. While Kwan testified, Nolan began making margin notes with theatrical precision, occasionally nodding along like he was grading the performance. Cross-examination was brief and desperate. Klein asking about spoofed IP addresses and planted evidence, but Kwan's technical explanations demolished every theory. The state calls Ms. Danielle Ellis. A college junior in a maroon hoodie walked nervously to the stand, clutching her phone. When she settled into the chair, she kept glancing at Nolan with a mixture of fear and confusion. Nolan offered her an encouraging smile and thumbs up that made her flinch. Danielle, you're a student at Hartley College? I was. I took a leave of absence this semester. Can you tell the court why? Last February, I got an email from someone claiming they had my academic records and my family's financial information. They said if I didn't pay $2,000 by midnight, they'd send everything to the student newspaper and post my failed grades online. Her voice grew stronger with anger. They knew things nobody should know, my father's mortgage payments, my mother's medical bills from when she had cancer, even my scholarship appeal letter. What did you do? I panicked. I transferred the money. Everything they mentioned was real. They even attached a screenshot of my transcript showing the F I got in organic chemistry. Did you discover who sent it? A few weeks later, another student heard someone bragging about blackmail operations. When I tried confronting him in the library, he just smiled and quoted my father's exact mortgage payment, a number from my scholarship application. Klein's cross was brief. You never saw my client send emails, correct? No, but he knew information only the blackmailer could have known. The state calls Detective Samuel Price. A broad-shouldered man with graying temples walked confidently to the stand, radiating the calm presence of someone who dealt with criminals who thought they were smarter than everyone else. Detective, you led the search of Mr. Voss's dormitory? Yes, we seized 2 laptops, an external hard drive, and 3 smartphones. On those devices, we found what I can only describe as a comprehensive criminal enterprise. He held up a printed spreadsheet, multiple encrypted folders labeled Winning Game and Leverage Database, containing detailed profiles on 14 students. Each file had their name, schedule, family financial information, academic problems, social media passwords, and what he called a pressure point analysis. Can you give an example? One file labeled Target Danielle V3.xlsex included Ms. Ellis's transcript, her father's mortgage info, her mother's medical bills, and a strategy memo reading, Best approach, academic failure plus family medical debt equal guaranteed compliance. Several jurors looked sick. We also found video files, recordings of himself explaining his methods. In one, he says, "The key to good blackmail is making people feel like they chose to comply. Give them a real problem and a simple solution, and they'll thank you for the opportunity to pay." From the defense table came an unmistakable laugh. Judge Rowan's gavel cracked. "Mr. Voss, final warning." We also found a document titled Courtroom Strategy with the line, "The key is appearing remorseful without actually feeling it. Judges eat that stuff up." After the lunch recess, as jurors filed back into their seats and the gallery settled into an expectant quiet, Scott Klein stood with the slow deliberation of a man about to make a decision he knew was probably wrong, but couldn't see any alternative to. "Your Honor," he announced, his voice carrying across the hushed courtroom, "the defense calls Nolan Voss to testify in his own behalf." A ripple of surprise moved through the gallery. Putting a defendant on the stand in any criminal trial was risky. Putting a teenager accused of systematic blackmail on the stand was either brilliant strategy or complete desperation, and everyone in the room could sense which one this was. Nolan rose from his chair with fluid grace, buttoned his gray blazer, and walked toward the witness stand like he was approaching a podium at a debate tournament. He knew he was going to win. He didn't just swear the oath, he performed it. Hand raised with perfect posture, voice clear and confident as he said, "I do." He settled into the chair with the casual comfort of someone sitting down for a friendly interview, one ankle crossed over his knee, hands folded in his lap. Scott Klein approached his client with visible reluctance. "Nolan, I know this isn't easy, but I want to give you the opportunity to speak for yourself. Can you tell the jury, in your own words, what happened here?" Nolan nodded thoughtfully, taking his time to make eye contact with several jurors before answering. When he spoke, his voice carried the kind of reasonable, articulate confidence that had probably gotten him out of trouble his whole life. "I think what happened," he said slowly, as if he'd given this considerable thought, "is that people got scared of things they didn't understand." He shifted slightly in his chair, the picture of earnest youth trying to explain a complicated situation to adults who might not grasp the nuances. "I've always been ahead of the curve academically. I was coding when I was 12, had my first website running by 13, scored in the 99th percentile on every standardized test I've ever taken. I've always been curious about how systems work, not to break them, but to understand them." His voice gained warmth, like he was sharing something personal. "When I got to college, I was fascinated by the network architecture. The security protocols intrigued me as intellectual puzzles. So I started exploring, not to steal anything or hurt anyone, but to see if I could figure out how the pieces fit together." Klein nodded encouragingly, though his expression suggested he was having trouble believing his own client. "So you're saying you didn't intentionally access confidential student records?" "I'm saying I was researching, learning. When you're studying cybersecurity, which is what I plan to major in, you have to understand how systems can be compromised so you can protect them better." Nolan's delivery was smooth, practiced, confident. Too confident. "Did I access files I probably shouldn't have? Yes. But did I do it with criminal intent? Absolutely not." "What about the threatening emails? The blackmail allegations?" Here, Nolan paused for just a moment, his expression shifting to something that might have been intended as confusion, but looked more like calculation. "I never sent any threatening emails. I think someone was using my network connection to make it look like the messages came from me. It's not that hard to spoof IP addresses if you know what you're doing. And the files Detective Price found on your laptop, the ones labeled Leverage and Winning Game, those were research projects, social engineering studies. I was documenting how easy it would be for someone to manipulate students if they wanted to, kind of like a white hat security assessment. I was planning to present my findings to the administration as a way to help them improve campus safety." It was a plausible explanation, delivered with absolute conviction. If you ignored everything else the jury had heard over the past 2 days, you might even believe it. Nolan, did you ever demand money from fellow students? Never. Did you threaten to release personal information unless students paid you? Absolutely not. Did you create what prosecutors are calling a blackmail operation? No, I created research documenting vulnerabilities in campus security and student privacy. If someone used that research for criminal purposes, it wasn't me. Klein nodded, looking almost relieved that his client was handling himself so well. No further questions, Your Honor. But then Maria Benton stood up. She approached the witness stand with the same calm deliberation she'd shown all week, carrying a tablet and wearing an expression that suggested she'd been waiting for this moment since the trial began. Mr. Voss, you testified that you were conducting security research, correct? Yes. And this research involved accessing confidential student records without authorization? I was studying system vulnerabilities. Yes or no? Did you access confidential records without authorization? Nolan's smooth confidence flickered for just a moment. Technically, yes, but thank you. Now, you mentioned that someone might have used your network connection to send threatening emails. Are you suggesting someone else had access to your laptop? It's possible. Dorm security isn't perfect. Benton nodded pleasantly, then tapped her tablet screen. Let's talk about the video files Detective Price found on your computer. The ones where you explain your methods and discuss your leverage empire. Those were also security research? Nolan's posture shifted almost imperceptibly. Those were theoretical discussions. Thought experiments. Thought experiments. Benton repeated the phrase slowly, like she was tasting it. In one video recorded February 15th at 11:47 p.m., you say, and I quote, Danielle Ellis is perfect, academic probation, family financial stress, and a scholarship review coming up. I could probably get 3,000 out of her easy. The courtroom was dead silent. Was that a thought experiment, Mr. Voss? I was exploring psychological pressure points as a theoretical exercise. And the next day, Ms. Ellis received an email demanding exactly $2,000. Coincidence? Nolan's jaw tightened slightly. I didn't send that email. Who did? I don't know. Benton walked closer to the witness stand. You also testified that you were planning to present your research to the administration. Can you show me any evidence that you ever intended to do that? Any drafts of reports? Any communications with faculty? Any indication whatsoever that this was legitimate academic research rather than criminal enterprise? Silence stretched across the courtroom. Mr. Voss? I was still in the data collection phase. For how long? Your first unauthorized access was in September. Your arrest was in March. 6 months of data collection with no academic purpose, no faculty oversight, no intention to share your findings with anyone who could actually improve campus security. Nolan's carefully constructed facade was beginning to crack. Research takes time. Does research typically involve creating payment accounts to receive money from your research subjects? I never received any payments. Benton consulted her tablet again. Detective Price testified that you had a Venmo account connected to a shell business entity called Campus Solutions, LLC. That account received 4 payments totaling $6,800 between February and March. All from students whose pressure points were documented in your research files. Nolan's voice sharpened with irritation. Anyone could have set up that account using my information. Using your social security number, your bank account, your personal email address as the recovery contact. Identity theft happens. So your defense is that someone stole your identity, used your computer, sent emails from your network connection, created fake research files in your name, set up payment accounts with your personal information, and then carefully arranged for all the evidence to point back to you. When she laid it out like that, the absurdity became obvious to everyone in the room. That's possible, Nolan said, but his voice lacked conviction now. Or, Benton continued, you're a 17-year-old who thought he was smarter than everyone else, got caught running a blackmail scheme, and is now lying under oath to avoid the consequences. Nolan's mask slipped completely. His expression shifted from confused innocence to something much darker, calculation mixed with contempt. You know what? He said, his voice taking on an edge that hadn't been there before. Maybe I did do it. Maybe some of those students deserved what happened to them. The courtroom erupted. Gasps, murmurs, the rapid scratching of pens. Judge Rowan's gavel banged repeatedly. Order! Order in the court! But Nolan wasn't finished. The careful, articulate teenager was gone, replaced by something colder and more honest. You want to know what I think? I think most people are sheep. They go through life taking whatever scraps they're given, never questioning anything, never pushing boundaries. They're weak. His lawyer was gesturing frantically for him to stop talking, but Nolan ignored him completely. I saw opportunities that they were too stupid or too scared to see. I had skills they couldn't even comprehend. So yeah, maybe I used those advantages, maybe I made some money along the way. So what? The transformation was stunning. The respectful student had vanished, revealing someone who viewed his fellow human beings as resources to be exploited. These people trusted a system that was designed to fail them. I just happened to be smart enough to see the flaws and profit from them. If they were too naive to protect themselves, whose fault is that really? Judge Rowan's gavel came down like a gunshot. Mr. Voss, you will stop talking immediately. But the damage was done. Every person in that courtroom had just witnessed the real Nolan Voss. Not the confused teenager his lawyer wanted them to see, but the calculating predator who viewed other people's pain as his personal entertainment. As the bailiff moved toward the witness stand, Nolan looked directly at the jury and smiled. You want to convict me? Go ahead. I'm 17 years old. Worst case scenario, I get juvenile detention until I'm 25, then I'm free to do whatever I want. And there's absolutely nothing any of you can do about it. The bailiff reached him then, but Nolan stood on his own, straightening his blazer like he'd just concluded a successful presentation. See you on the outside, he told the jury, and then he was gone, escorted back to the defense table where his lawyer wouldn't even look at him. The trial should have ended right there. In any reasonable world, Nolan's confession, because that's what it had been, despite the legal technicalities, would have been the final word. But procedure demanded closing arguments, jury deliberation, and a formal verdict. Scott Klein's closing argument was mercifully brief and utterly hopeless. Ladies and gentlemen, he said, looking like a man trying to defend the indefensible, what you witnessed today was the breakdown of a mentally ill child. My client's outburst proves what we've been saying all along. He needs help, not punishment. He needs treatment, not condemnation. Even Klein seemed to know his words were falling on deaf ears. How do you ask for mercy for someone who just bragged about exploiting his victims and threatened to continue his criminal activities the moment he was released? Maria Benton's closing argument was more pointed and infinitely more effective. You heard him, she said simply. In his own words, from his own mouth, you heard exactly who Nolan Voss really is. She walked slowly in front of the jury box, making eye contact with each person. You heard him describe his victims as sheep and naive. You heard him express no remorse, no regret, no recognition that what he did was wrong. You heard him threaten to continue his criminal activities the moment he's released from whatever minimal consequences he expects to face. Her voice remained calm, but there was steel underneath. Nolan Voss didn't commit these crimes by accident. He didn't make mistakes that spiraled out of control. He systematically researched, planned, and executed a campaign of terror against people who trusted him. And when caught, he laughed about it. She paused, letting her words settle. He told you himself that he sees people as resources to be exploited, that he views kindness as weakness and trust as stupidity, that he believes intelligence gives him the right to prey on others. Another pause. The question isn't whether he's guilty. He confessed on the witness stand. The question is what message this community sends to other brilliant minds who might be tempted to follow his path. She returned to her seat. Make sure that message is clear. The jury deliberated for 3 hours and 47 minutes. When they returned, their faces showed no uncertainty, no internal conflict, just the grim determination of people who'd witnessed something that required a response. Nolan sat calmly as the verdict was read. Guilty on all 4 counts. His only reaction was a slight nod, as if the outcome confirmed his expectations about how predictable the justice system was. He had no idea what was coming. 3 weeks later, the same courtroom filled again for sentencing. This time the gallery was packed. not with curiosity seekers, but with people who had a personal stake in the outcome. Students from Hartley College who'd lived in fear for months, parents who'd watched their children struggle with anxiety and paranoia, university administrators who'd seen their campus community torn apart by systematic predation. Nolan walked in wearing the same gray suit, carrying the same leather notebook, wearing the same confident expression. He took his seat at the defense table like a businessman arriving for a board meeting he expected to control. Judge Rowan entered with the weight of someone about to make a decision that would echo far beyond her courtroom. "Before I impose sentence," Lexi began, looking directly at the defendant, "I want to address something that has been raised repeatedly throughout this trial and will undoubtedly be raised again on appeal: the defendant's age." Nolan leaned forward slightly, that familiar smirk forming on his lips. "Mr. Voss, you and your attorney have argued that your youth should be considered a mitigating factor, that 17 is too young for full criminal responsibility, that your judgment was still developing, your understanding of consequences still incomplete." Judge Rowan consulted the file in front of her. "I have presided over juvenile cases for more than 2 decades. I have seen children who made terrible mistakes in moments of passion. I have seen teenagers whose crimes resulted from abuse, mental illness, or desperation. I have always believed in the possibility of redemption, in second chances, in the fundamental difference between adult criminals and wayward youth." Her voice grew colder. "But this case is different, Mr. Voss. What you did was not a mistake. It was not a moment of poor judgment or youthful indiscretion. It was the systematic exploitation of vulnerable people by someone who viewed their suffering as entertainment." The smirk was fading now. "Your own words, both in your digital communications and from the witness stand, demonstrate a level of calculated cruelty that transcends age. You didn't stumble into these crimes, like you researched them for months. You didn't accidentally hurt people. You specifically targeted those you identified as most vulnerable to manipulation." Judge Rowan stood, her black robes making her seem larger than life. "Most troubling of all, when given the opportunity to show remorse, you chose instead to mock your victims and threaten to continue your predatory behavior the moment you were released." For the first time since the trial began, uncertainty flickered across Nolan's face. "The law allows juvenile offenders to be sentenced as adults in cases involving sophisticated criminal enterprise and demonstrated lack of amenability to rehabilitation. This court finds that your crimes clearly meet those standards." The word adults hit Nolan like a physical blow. He sat up straighter, the confident slouch replaced by rigid attention. Furthermore, the aggravating factors in this case, the systematic nature of the crimes, the number of victims, the psychological sophistication of the manipulation tactics, and most importantly, your complete lack of remorse and explicit threats to reoffend warrant the maximum penalty available under law. Nolan was leaning forward now, his casual demeanor replaced by something approaching panic. "Therefore, it is the judgment of this court that you, Nolan Samuel Voss, are sentenced to 25 years in federal prison without the possibility of parole." The words hit the courtroom like a thunderclap. "No!" Nolan shot to his feet so fast his chair tipped over with a crash that echoed off the walls. "You can't do that. I'm 17. There are laws, protections." Gone was the calculating mastermind who had confessed so casually to systematic predation. In his place stood a terrified teenager who suddenly understood that actions have consequences, that intelligence wasn't a shield against justice, that the game he thought he was playing had rules he'd never bothered to learn. "This isn't legal. Someone has to stop this." He spun toward the gallery, searching desperately for a sympathetic face, for someone who would step forward and save him from the reality he'd created for himself. He found none. "I'm just a kid." His voice cracked on the words. "I didn't know what I was doing. This is too much. This is cruel." Two bailiffs moved toward him, but Nolan continued shouting, his carefully constructed facade completely shattered. My life is over. You're destroying my future. I was supposed to go to MIT. I was supposed to change the world. Judge Rowan's voice cut through his panic like a blade. Mr. Voss, you had the opportunity to change the world. You chose instead to terrorize it. You wanted to be treated like an adult criminal. Congratulations. You got your wish. The bailiffs reached him as he collapsed back into his chair, the fight gone out of him as suddenly as it had appeared. Please, he whispered, the word barely audible above the courtroom's silence. I'm sorry, I didn't mean it. I was just scared. Please don't do this to me. But it was too late for apologies. Too late for the remorse that might have mattered if he'd shown it before he was caught, before he was cornered, before he realized that his intelligence couldn't manipulate his way out of every situation. As the bailiffs led him away, Nolan's legs seemed to give out. They had to support him as he stumbled toward the door, his confident stride replaced by the uncertain shuffle of someone whose entire worldview had just collapsed. The courtroom doors closed behind him, with the sound of finality itself. Judge Rowan remained standing as the gallery slowly emptied, people filing out in stunned silence. Some seemed satisfied that justice had been served. Others appeared shaken by the severity of the sentence, but all of them understood that they'd witnessed something significant, not just the conviction of a criminal, but the dismantling of a young man who'd confused intelligence with superiority and discovered the difference too late. Outside the courthouse, reporters waited with cameras and questions, eager to broadcast the story of the teenage hacker who'd received an adult sentence for adult crimes. But inside the now empty courtroom, there was only silence and the lingering weight of consequences that would reshape not just one life, but the lives of everyone who'd been touched by systematic predation disguised as intellectual superiority. Nolan had wanted to be remembered as a genius. Instead, he'd become an example, a cautionary tale about what happens when brilliance serves cruelty instead of compassion. The appeals would come, of course. Lawyers would argue about juvenile sentencing guidelines and constitutional protections. Legal scholars would debate the appropriateness of adult sentences for teenage offenders. But for the students who'd lived in fear, for the families who'd watched their children suffer, for the community that had been terrorized by someone they'd trusted, the verdict felt like the only possible response to an impossible situation. Some crimes are so calculated, so devoid of empathy, so threatening to the fabric of society that age becomes irrelevant. Some people demonstrate such complete contempt for others' humanity that rehabilitation becomes impossible. And sometimes justice requires acknowledging that monsters can be brilliant, articulate, and 17 years old. What do you think? Was Nolan's 25-year sentence appropriate justice for a 17-year-old, or does his age warrant more lenient treatment, regardless of his crimes? Should the justice system punish arrogance and lack of remorse as severely as the underlying criminal acts? Let me know your thoughts in the comments. These are the cases that challenge everything we think we know about youth, intelligence, and accountability. If this story made you think twice about the nature of justice and consequences, make sure you hit that subscribe button and tap the notification bell. Share this with someone who believes in having difficult conversations about the intersection of brilliance and cruelty. More cases that will challenge your assumptions are waiting in the playlist. Pick one now, and I'll see you tomorrow with another story that explores the darkest corners of human nature and the legal system's response to them. Thanks for watching. And remember, sometimes the most important lessons come from the most uncomfortable truths.